Thank you. Well, it's my distinct pleasure to welcome you all here. It is so nice to see so many people here in person. I was wondering what the audience would look like, and then we started getting our SPPs, and we had to go and find some additional chairs in the building to be able to fit everyone. So I appreciate you all coming. We are also webcasting this on the web. My name is Sebastian Gomez. I'm the acting Deputy Director over Legal and Regulatory Policy in the Division of Corporation Finance. And I'm so excited about today's roundtable. A few logistics. I'm going to welcome the chairman to provide some remarks, followed by Commissioner Peirce and Commissioner Ueda. Commissioner Crenshaw, unfortunately, was not able to join us today. She would like to be here, and instead she will be providing remarks that will be published on the SEC website. Since we have a lot to cover, I am not going to spend more time here, and I'm going to just turn the podium over to Chairman Atkins. Chairman.
Make it official. Super. Well, thank you, Sebastian, and it's great to see everybody here, and hopefully you made it through the line okay upstairs in the lobby. But it's a pleasure to see so many familiar faces as well who are here. So I welcome all of you who are attending here in person, obviously, and then watching and listening to today's roundtable on executive compensation. I thank the very distinguished group of panelists who are assembled here today for volunteering their time to contribute your thoughts on this important topic. So as one of the enumerated disclosure items in Schedule A to the Securities Act of 1933, the requirement to provide executive compensation information is as old as the federal securities laws themselves. Over the past 90 years, the Commission has adopted numerous rules requiring more and more information about executive compensation. Some of these rules have come about from congressional mandates, while others have not. So actually, I've been at the SEC in one role or another for a couple of these changes, including the 1992 rulemaking initiated by Chairman Richard Breeden that created the summary compensation table. And then after that, when I came back as a commissioner, the 2006 rulemaking that introduced compensation discussion and analysis and added other compensation tables. So today one might describe the Commission's current disclosure requirements as a Frankenstein patchwork of rules. The volume and complexity of these rules may be just as scary to a law firm associate, I was one of those once upon a time, performing a form check of a proxy statement, as the monster was to Dr. Frankenstein himself when the monster opened his eyes. So the Commission amended Item 402 of Regulation SK in 1992 to state specifically that, and I quote, "This Item 402 requires clear, concise, and understandable disclosure of compensation," unquote. So one could say that this well-intentioned 3-decade-old statement has perhaps become a little bit facetious with the passage of time in light of the lengthy narrative disclosure and the numerous tables and charts that appear in today's proxy statements. Our rules must be grounded in achieving the Commission's 3-part mission, and that is investor protection, fair, orderly, and efficient markets, and capital formation. These rules should be cost-effective for companies to comply with and provide material information to investors in plain English. Most importantly, the information required to be disclosed should be material to the company and understandable to the Supreme Court's objective, reasonable investor. The outcome of our rules is not effective when companies require highly specialized lawyers and compensation consultants to prepare disclosure that the reasonable investor struggles to understand. Today's roundtable is one of the first steps in considering whether the current executive compensation disclosure requirements achieve these objectives, and if not, how the rules should be amended. In connection with this process, I previously asked the Commission staff to consider several questions in this area for the public to provide their views on those questions. So thank you to those who have already submitted comment letters. For others who intend to submit a letter, please do so as soon as possible over the next several weeks to provide the staff time to consider and incorporate your views into any potential rulemaking proposal that will come along. Thank you to the staff of the Division of Corporation Finance, the Office of Support Operations, the Office of Information Technology, and the Office of Public Affairs for organizing this roundtable. I very much look forward to your discussion this afternoon. Unfortunately, I won't be able to stay here the full time, but I'm sure I will listen to it here over the next few days. So thank you very much, and good luck, and look forward to the outcome. Thank you.
Good afternoon, and thank you all for being here. Thank you, Chairman Atkins, for convening today's roundtable, and I appreciate those of you who are moderating and serving as panelists today to discuss this important topic. On a recent trip to Alaska, one of the most striking sights for me was the beautiful mountainsides of trees that were lining the water. And I quickly stowed my binoculars in favor of looking at that whole scene, which was really quite magnificent. Absent a distinguishing feature, maybe a special kind of tree or an intriguing root system, a bald eagle perched in the branches or a bear lurking in the shadows of a tree, the grandeur of the forest is really lost when you look at individual trees. Trying not to lose sight of the forest for the trees in beautiful Alaska brings me back, of course, to executive compensation disclosure and the ugly reality of what it is. Over the years, executive compensation disclosure has become increasingly unwieldy and expensive and decreasingly useful. The SEC's rules focus excessively on random trees rather than giving a realistic view of the forest. They direct readers' attention to a set of executive compensation items that largely entertain the onlooker rather than educate the investor. Preparing lengthy and complex disclosures eats up lots of resources, management time and attention, attorneys and accountants' billable hours, and even trees as the pages of disclosure pile up. And they distort corporate decision-making. Done right, disclosure rules are one form of investor protection. Material information provided to prospective investors arms them with a rational basis to evaluate a company and its resources and its securities, in the words of Alan Levinson. My primary question for today's panels is whether our current disclosure rules on executive compensation accomplish that goal. Some executive compensation rules seem more responsive to the general public's curiosity than a genuine investor need for material information. Painstakingly calculated tallies of perks like rides on the corporate jet, housing allowances for overseas assignments or car services give us a little window into executives' lives, but do little to fill out an investor's picture of what the company actually is. Lately, our rulemakings have taken a more is better approach to executive compensation disclosure. These tack-on rules to the growing alphabet of Item 402 of Reg SK, we're almost all the way through the alphabet, do not provide new information. Instead, these rules repackage and represent data that investors mostly already have, or they add details that are immaterial. Do investors even look at this new information? And if they do, are we confident that it gives them a rational basis to evaluate a security's price? Consider, for example, pay ratio disclosure and pay versus performance disclosure. In his statement of dissent on the pay ratio rule, then Commissioner Dan Gallagher noted that it could have been, quote, marginally less useless if it were limited to U.S. full-time employees. While not quite a ringing endorsement of the rule or any of its possible permutations, his comment highlights that even with respect to a rule that's mandated by Congress, as this rule was, the Commission retains some latitude to implement it in the best way possible. More recently, pursuant to another Dodd-Frank mandate, the Commission adopted the pay versus performance rule. The overarching feedback I hear on that rule is that it's a regulatory tax on public companies without a corresponding benefit for investors. Management and the high-priced consultants and lawyers they hire spend hours preparing the various narratives, and this is no offense to anyone in the room, spend a lot of time preparing those various narratives, tables, and graphs that produce nothing but yawns of disinterest for investors. More concerning than the direct costs of producing executive compensation disclosures, however, are the costs that arise from the distortion of corporate behavior in response to disclosure mandates. Perhaps a company opts for a compensation scheme that is less effective at aligning incentives because of the way such a scheme will be reflected under SEC disclosure rules, and that may not exactly or actually represent economic reality. Or perhaps a company opts not to provide security for its executives because it appears in a laundry list of examples of perks in a 2006 Commission release that declines to even define what a perk is. Now may be time for the Commission to return to a more nuanced approach to personal security disclosure that considers the context in which those measures are provided. Some companies even have gone so far as to eliminate perks altogether while offsetting such cost-saving measures with increases to base salaries. Executive compensation disclosure, along with other disclosures, should reflect rather than direct corporate actions. The age-old philosophical question is whether a falling tree makes a sound in the forest when there's nobody around to hear it. The more relevant and less philosophical question for today's discussion is if the disclosures we're mandating do not provide investors a rational basis to assess a company, why mandate them at all? I look forward to hearing from today's panelists and moderators about how we can improve our executive compensation disclosure mandates. Thank you.
Well, good afternoon, everyone. Great to see everyone here in person at the Commission. So I also want to give my thanks to Chairman Atkins for convening today's roundtable. And I look forward to engaging in a dialogue with panelists and commenters on whether the executive compensation disclosure framework can be improved. Already, the Commission has received a number of comment letters on executive compensation, which is posted to our website and which I found helpful in preparing for today's roundtable. Now, at the outset, the Commission has no statutory authority to set or limit compensation paid at public companies, whether with respect to executives, workers, or contractors. SEC executive compensation disclosures should not drive compensation decisions or seek to influence compensation practices. Moreover, it is inappropriate to use SEC regulations with the intent of addressing desired political or social outcomes with respect to income and wealth inequality in the United States. To the contrary, executive compensation disclosure should provide information material to an informed investment or voting decision. Attempts to control executive pay through indirect means have often proven clumsy and result in the exact opposite effect. In the 1990s, Congress passed tax legislation to make it less favorable to provide chief executive officer salaries in excess of $1 million. Rather than limit CEO pay, the legislation significantly accelerated equity-based forms of executive compensation. In 2006, our then chairman, Chris Cox, described this effort, which backfired as, with complete hindsight, quote, "We can now all agree that this purpose was not achieved. Indeed, this tax law change deserves pride of place in the Museum of Unintended Consequences," unquote. Other executive compensation disclosures appear to have dubious purposes. The CEO pay ratio is one such example. There appears to be little nexus to investor protection concerns. Instead, aspects of the CEO pay ratio rule and the underlying Dodd-Frank statutory provision seem to have a name and shame motivation. The Commission's rulebook should not serve to further political agendas, in addition to distracting from the Commission's primary mission of providing material information with respect to executive compensation. This rule also increases regulatory compliance costs without providing any corresponding investor benefits. We've received many recent comment letters on executive compensation that are critical of the CEO pay ratio disclosure. One letter noted that, quote, CEO pay ratio does not provide an accurate comparison of pay equity within organizations, as various industries have different workforce and compensation structures, which prohibit meaningful evaluation, unquote. Another recent letter stated that the CEO pay ratio, quote, does not appear to have played a material role in compensation committee discussions, investor decision-making, or the rapid rate of increase in executive pay relative to that of the wider workforce, unquote. Disclosures that are both costly and complex to produce, while not material to investment or voting decisions, are at odds with any form of good regulatory disclosure. Regarding the adoption of clawback rules, the scope and impacts of the rule may have increased uncertainty. Specifically, market participants indicated that there is a lack of clarity as to what types of accounting errors need to be analyzed and when boxes need to be checked. Further, third-party analysis indicates that few companies have analyzed the underlying accounting errors potentially requiring a clawback. As such, the benefit of this framework appears minimal. Now, perhaps these issues could have been avoided had the Commission, if not for its haste, had not decided to rush in 2022 to adopt a proposal from 2015 left over from the Obama administration without first perhaps updating its economic analysis. And second, maybe we should have engaged with stakeholders as to how best to implement that rule. Similarly, the recent pay versus performance rule adoption relied on stale economic information. We relied on data that went back as far as 25 years prior to the date of the reopening of the comment period. And moreover, perhaps companies will be relieved to hear this, but we relied on paperwork reduction estimates that were 16 years old. So we assumed that your legal costs were only $400 per hour. Now, I've been told that that's a blended rate. Since 2006, the Commission has added numerous requirements to the executive compensation disclosure on a piecemeal basis without undertaking a review of the overall reporting environment. The Commission is long overdue for a review of both the executive compensation disclosure rules from the perspective of what information gets reported, as well as from the lens of whether scaled disclosure is appropriate depending on the size of the reporting company. Any rules should promote transparency into compensation frameworks and structure rather than function as a tool to dictate compensation decisions. In 1992, then Commissioner Richard Roberts addressed these concerns when he stated, quote, "The Commission is not interested in dictating the level of pay for corporate executive officers. That is the job of the Board of Directors, as elected by the shareholders. The Commission's interest and jurisdiction in this area is limited to full and fair disclosure," unquote. Those words still ring true today. The Commission should refrain from expanding its rulebook simply because some may think that executive compensation is too high. So I thank everyone on our staff for their efforts in organizing today's roundtable. I thank all of you for coming out and attending in person, and for all of your future, if you haven't made a submission already, the future submissions as we think about this very important and timely topic. Thank you.
Thank you, Chairman and Commissioners, for those remarks. We are not going to waste any time, and I'm going to ask our first panel to go to the table. As you can imagine, we have a lot to cover today, so I've asked the moderator and each of the panelists to jump directly into the substance. We are not going to go through bios, but their bios are on the website, so if you are interested in that, please encourage you to take a look at that. And with that, Keir, I am going to turn it over to you. Thank you so much.
Great. Thank you very much, Sebastian. And again, thanks to all of you for joining us this afternoon. We're going to have a great discussion this morning. We're going to focus really on three questions. We're going to try to answer three questions at least. The first, and in the context of executive compensation, who sets executive compensation? What are the factors that influence the compensation decision-making and the process by which compensation decisions are made, generally incorporating the views of institutional investors and other parties? I'm joined by a fantastic panel representing public company directors, executive compensation practitioners, executive compensation advisors, and of course, institutional investors. I'm thrilled and excited. We have an hour and a half. We can spend 3 hours on this. So we'll do our best to kind of compress all of the rich discussion that we had in preparing for this discussion today. So Deborah, if you don't mind, I may actually start with you. Who generally is involved in the process of setting executive compensation at a firm?
Thank you, Kieran. Good afternoon, everyone. It's an honor to be here, I'm sure, for all of our panelists. So do you want to just repeat the question?
Sure.
And I'll...
Yes. So who is involved in the process of setting executive compensation at a company?
Well, I'm the chair of the HR committee at PNC, and compensation is a really year-long, continuous process, and there are many parties involved. At PNC, the board has delegated the leadership for executive compensation to the HR committee, or we'll call it the HR committee or the comp committee. And we meet many times per year. We are supported by the management team within the company as well as independent consultants. Everybody on the compensation committee, of course, is an independent director. We engage multiple times throughout the year with people in the risk department, the chief human resources officer. We also engage regularly with other board members. We report to them. We review market data, of course, and we're informed by feedback that we get on compensation trends. We're, of course, informed also by investor feedback that we receive on a regular basis. And those are some of the key participants. We also consider over the course of the year management's recommendation about the performance of certain NEOs. We get performance updates as well from the NEOs and performance evaluations about them.
Very helpful. So year-long process. Management is involved. The board is involved. I'm going to come back to that. You talked about advisors being involved in the process, and we've got some great advisors up here, so I'm going to ask some of you to weigh in on that. There are investor perspectives and other members of management. And so, Michael, maybe I'll turn to you next. Does that align with your experience in terms of who's involved in the process?
Yes, completely. I would say that the answer to that question remains static over time, at least in the 30 years that I've been doing this work. It starts with the board and its compensation subcommittee. To Deborah's point, the compensation subcommittee has taken on a broader remit in recent years to focus on broader HR issues, but it still does the core compensation approvals. It's the independent consultant to that committee, and it's the management team. And when I think about the work that gets focused on and the committee's remit with respect to compensation items, I think about it really in three buckets. It's sort of very high-level principles around compensation philosophy. It's how do you define the labor market as approximated by a peer group? It's what is your desired position in terms of how you want to pay relative to that peer group? It's the mix of pay elements. It's a broader pay-for-performance relationship that we're trying to affect. And then there's another category that's sort of substantive programmatic things. It's the design of annual and long-term incentive plans. It's important policies around stock ownership requirements, change of control and severance, that type of thing. And then there are a lot of items that the committee approves, again with the assistance of the consultant and the management team, that relate to the normal cadence of setting performance goals on the front end, evaluating performance against those goals on the back end, and figuring out what the compensation consequences of that result are. And then there's a lot of work that goes around, setting compensation prospectively as well. So that's my experience on the management side. It's always the CHRO. It's the head of reward, sometimes the head of executive compensation. And then depending on the topic at hand, it could be the CFO, it could be the legal team, including the corporate secretary. It could be, all of those people. The CEO is involved, obviously, except with respect to the determination of his or her own performance and compensation.
So we've had a couple references on this panel to advisors, and we have the good fortune of having two advisors who are part of this process, part of this discussion that we're having today. I wonder, Ani or Blair, if there's anything you might add to that perspective that's been shared so far.
I can start. So the reference to the independent consultant, that's the role that we play. So during the year-long process that Deborah was referring to, we are the independent partners to the committee, making sure that the right conversations take place at the right times with the right people in the room in the right ways. So if you think through the different discussions that Michael was talking about, we make sure that the principles are there and they've been revisited each year because they do change as your strategy changes. They change if you have new leadership. They change if you have a transaction and you're a different kind of company. So we're making sure that that conversation takes place. We're working with the chair to make sure that the peer group is up to date, that it makes sense to the external world as the investors are looking at it, and it makes sense to the company internally in terms of who they're hiring from and losing people to. We're helping with the design part that Michael talked about, showing what other companies are doing, thinking about what the strategy suggests. So if you've got a growth strategy, you might have a different set of measures and a different mix of pay than if you're a mature company trying to optimize your operations and be highly productive. And all of that suggests different outcomes that it's valuable for the committee to discuss and revisit over the course of time. Goal setting needs tires kicked, so we usually work with management, the finance team, and the total rewards head to help make sure that the goals are rigorous and that they reflect the plan and the expectation of the investors. We help test the pay and performance relationship that Michael was talking about. So are we getting the right pay outcomes for the performance that's being delivered? And then finally, are we working with legal and outside legal advisors in the right way to make sure that we're complying and disclosing things in the right way? So we're a partner throughout that process independently for the committee and working with management to make sure that their strategy and also their cultural priorities and talent priorities are reflected.
Ani, what would you add to that?
So I would just add that you've heard, everybody talk about 11 billion people that are engaged in determining CEO pay and figuring out how best to design it. The person who is the least involved is the CEO. I mean, I think I just want to really make that clear, that sometimes there might be this feeling that it's management and the CEO who's driving CEO pay, but I think that the panelists have made that really clear that, in fact, that's not the case. I would also say, so with the Center on Executive Compensation, we're part of HR Policy Association, which is the community for chief HR officers of large companies. And this is the one area within their remit that they are so really focused on getting right and having be so rigorous and independent that we had to create an entire center on executive compensation just for them, just for this topic. So I think that really speaks to the focus on it. We often say at the center, executive compensation is unique because it is a powerful form of communication to a variety of stakeholders. And that's never been truer than now when we have these extensive disclosures that sometimes communicate things we don't want to communicate. So I think that's partially why there's so many resources devoted to this topic.
All right, Ani. Ola, Peter, I'm going to come to you in a moment, but I want to challenge something you said. if that's okay.
Of course.
So you said the CEO is the least involved in this process. Now, what I heard Michael say was the CEO is not involved in setting his or her own compensation. So can you reconcile those two statements?
Yes, so I should have said in his or her own compensation.
Got it.
For sure.
Okay,
Yeah.
okay.
CEO is definitely involved in the compensation of his or her direct reports, as you would expect, but not in his or her own pay.
Got it. Perfect. Thank you. Okay, Ola Peter, you might have a view as an investor.
Thank you. Yeah. We get involved, increasingly so, I would say, not only just before the shareholder meeting, but throughout the year. But before I go into that, a big thanks to the SEC for setting up this roundtable, and thanks to everyone participating here and on the stream. Thanks for inviting me and my institution, the Norwegian Fund, which reaps the benefits of investing in the United States. The majority of our global equity portfolio is invested here in America. And one of the things we love, if you can say that, or at least I can say like in the like in the US, is how companies emphasize equity-based pay, and how CEOs owns stock in the company. We like it in particular when that stock commitment is long-term and irrevocable. However, it has become slightly more complex for companies over the last, say, 20 years. You could say the freedom for companies to pay in such simple stock structures have become curtailed. And it's almost become a market norm that equity-based pay, or the majority of it, should be paid in much more complex performance share units. Another concern that we can come back to and discuss is that the companies that lock in those shares for longer than the usual 3 years don't get the credit they deserve for that. And that's a little bit strange, because that's one thing many investors would like to see, a long-term lock-in of equity-based pay. So you could say executive compensation has gotten more complex, more intricate, and maybe even to the point where you could discuss how well say on pay works today. This is a question we will, I guess, come back to and discuss through this panel, whether any update to the disclosure rules, which is maybe part of the issue here, can help us out of this suboptimal situation. So we can come back to all of that. I just wanted to provide you with a little bit of a flavor on why we get involved in discussing pay with individual companies we own, as well as in the broader discussion on market practices here in the US. So thank you.
I want to throw down a pin for a couple things that you said that I want to make sure we come back to. One of the things that you mentioned was that it's harder to use simple stock structures, and you referred to PSUs specifically. And so I'd like to come back to that, and whether the disclosure rules are influencing that difficulty, or whether it's investor behavior or something else. So that's one thing. You also mentioned the role that the disclosures play in your investing decisions and proxy decisions, which certainly a topic we'll come back to. One of the phrases that one of the commissioners mentioned earlier was this idea of a tree falling in the woods. If a tree falls in the woods. So if disclosure disappeared, that's the tree falling in the woods, would that make a difference for your investment and voting decisions? And I'd love to come back to that later if we could. Before we do that, though, Deborah, I want to come back to you. In your remarks, you mentioned, and I'm asking you this in your role as chair for the Human Resources Committee at PNC. From that vantage point, you mentioned earlier the role of the Compensation Committee versus the rest of the board. And I wonder if, for the audience, if you can unpack that a little bit more. What's that relationship like?
Yes. So the relationship is very similar to the other major committees that investors would be familiar with, which is the board is really delegating to a skilled, sort of experienced subset of directors the oversight and management of executive compensation, and certainly under our charter, which is very clear about our scope of responsibilities, other parts of compensation within the firm. And I would just describe it as we are doing the heavy lifting on behalf of the board, ultimately on behalf of the shareholders, to recruit, retain, and motivate the key employees of the organization. And we then do the heavy lifting. It's a very rigorous process. We spend a lot of time, like most of the other committees, the chair would pre-meet to understand the agenda, the content, the materials, the analysis that would be presented to the committee. Then the committee would meet and talk about whatever the content of that particular agenda item is, and that happens maybe 6 to 8 times a year. And then at every board meeting, we present a chair's report to the full board that explains what happened in the meetings, give the other board members a chance to ask questions. I try to make sure we educate the board members who may be experts in technology but not in executive comp, what these decisions mean for the corporation, for the NEOs. And then the directors who aren't on the comp committee have a chance to engage and ask questions. And when we would talk about the CEO comp, we often do that outside the presence of the CEO. And so that's how it works. Just like you would expect with audit or a technology committee or a governance committee, we're doing the detailed, deep work that we can then do on behalf of the board, on behalf of the shareholders.
It's very helpful. I wonder, I want to emphasize a couple things you said there. You mentioned 6 to 8 meetings in addition to the regularly scheduled meetings. Is that right?
6 to 8 HR committee meetings, but then as chair, there's always a pre-meeting.
Right.
So you can multiply by 2.
So that's 12, yeah. So 12 to 16 meetings. And the reason I wanted to emphasize that is just that you used the word heavy. It's a lot of work.
It
If
is.
you're a member of a compensation committee. I think often there's an assumption audit committee has the heaviest lifting, and that may be true. Ton of work, it sounds like, for a compensation committee. So I just thank you for sharing that. Very helpful. So I'm curious, Ani, I'm looking at you as I say this. What are you seeing? Is that consistent with the industry?
Yes, and not only, my voice is so loud, you can probably hear me anyway, but I'll turn the mic on. Not only is it consistent, I would say that the Comm Committee chair, well, personally, I think they have the heaviest lift. But I think that what we find among our members is that there's then all of these meetings that are occurring to prepare for the prep meeting with the Comm Committee chair. So you can actually now add another at least dozen meetings onto that because where everybody's having a prep call for that. One of the things I think it's clear from what Deborah said is that although management may be very engaged in the process, in bringing to bear, all kinds of data and talking about the company culture and the philosophy, among our members, there's a very deep and strong understanding that the comp committee is the one making the decision and that the comp consultant is employed directly by the comp committee. So I just also wanted to mention that. There's I think among our members, certainly a very, very strong understanding of that. And that's why they want to make sure they have every single bit of information that either the comp consultant or the comp committee chair would need.
So we've mentioned a couple of outside helpmates, so to speak, for the executive compensation practice. We talked about advisors, so that's one. I heard law firms are another one. What about some of the calculations? So you think about either the pay ratio table or the pay versus performance. Are there other players that are part of that process? And that's really maybe a question for the group.
Yeah, I'll take a first pass at it. I think most of the calculations are done internally by the management team. It requires a Herculean effort to produce all of the numbers that go into the tables. There are certain tables that generally require outside assistance. When I think about the pay versus performance table, that requires the revaluation of all outstanding equity awards, and equity awards can be quite complicated. So you're not just valuing the award when it's granted and as it appears in the grants of plan-based awards table. and the summary comp table, it's being revalued every single year to reflect the experience that has happened since the grant date. That's got to be done for every single award, every stock option, every PSU that's got a market condition that's share price based, relative TSR, et cetera. That is expensive, and it requires a lot of outside assistance.
And I'm curious, who's providing that assistance? Obviously, we know, Blair, that your firm, among other firms, provides that kind of work. But are there other, whether it be, actuaries, account CPAs, like who is that constellation of service providers that executive compensation experts like you rely on in doing the calculations or other disclosure preparation?
Yeah, so we actually don't do the valuation work. There are outside firms that do that work that are not the standard independent compensation consulting firms. And then the other people who come in are accounting experts and tax experts as you're trying to structure different compensation arrangements and they have different implications, then those people have to be brought in as well. And that often creates extra meetings, at least for the chair, but often for the committee as well.
It's very helpful. And I'm going to go back to a theme for this panel, going off script a little bit. How much of this is driven by the rules and how much of it is driven by practice? Just what we've talked about so far.
I think I'm comfortable in saying that 100% of the work on the pay versus performance table is driven by the rules. So I think that there's almost no company that I know of that would be doing those calculations in that way if it wasn't for that rule. I would say something similar for the tables that follow the summary compensation table. It's not that nobody is using them now, but the question you asked was, why are we doing these calculations? It's because the rule is requiring it. The third one I would say is even with the Dodd-Frank pay ratio. So when that came up, there was a question of, I think some policymakers said, well, what do you mean you don't know what the median employee globally makes? And the reason we didn't know that is because there was no business reason to calculate pay the way they were defining it and then figure out who that median employee was globally. So no company was doing that. So then again, that's a calculation we had to pay for that was solely because of the SEC rule.
Very helpful. Okay, there is one more set of stakeholders we haven't mentioned in this conversation, which are the proxy advisory firms. And so I'd love, Michael, maybe I'll start with you on this one. What role do the proxy advisory firms play in this overall process of setting executive compensation?
Yeah, I would say that it's a tangential role. Most companies, in my experience, do certainly consider the policy guidelines that the proxy advisors publish. If you don't, you sort of do it at your own peril. I don't think it dictates what companies do, but it's certainly a consideration. In my experience, a lot of companies, including companies that I've worked for, do avail themselves of the consulting services that they offer. So. And there are software tools, including pay-for-performance modelers, that essentially replicate the policy guidelines for some of the diagnostic tests that you can pay to use. So it would be, it's imprudent to ignore that. I don't think that like I said, I don't think it dictates what companies do, but it's a consideration, just like peer practices are a consideration. We try to triangulate answers based on all of the available information, and then we make it bespoke for the company's specific objectives.
Okay, I'm going to challenge that, if that's okay. So it's been my experience, not completely challenged, by the way, but it's been my experience that when you're designing your program overall, you're thinking about the elements of compensation, the design of your plans, for example, that the proxy advisor guidelines could actually play a pretty significant role in the things that you're deciding to establish, just from a framework perspective, even if the individual decisions themselves may be more bespoke. What do you think about that? Or if others have a perspective on that, I'd welcome them as well.
Yeah, I mean, I agree with you, and that's kind of why I was saying that I think it's a consideration. So when you think about the strong preference for what's deemed performance-based compensation, I think that probably does affect the way in which companies structure long-term incentives. Generally, and I'm not going to call out any specific proxy advisor, but in general, stock options are not considered performance-based. Restricted stock units are not considered performance-based. And if there's a preference to have at least half of the long-term incentive portfolio being performance-based, you know that you can't have more than 50% in RSUs and stock options, or you risk, you risk problems in terms of say-on-pay vote recommendations.
Ola Peter?
Yeah, I'm happy to provide the perspective on that. From our perspective as a diversified investor, we're holding 1,800 U.S. companies in our portfolio, almost 9,000 companies globally. Clearly, the proxy advisors are necessary and useful for us in gathering information, presenting it to us in a readable, quasi-standardized format, and also, which is not the topic today, but also quite important, in helping us execute our vote intentions across the globe. So they are super important, very helpful service. But on this item, I must say we strongly disagree with their policy that you just spoke about, Michael, and which I touched on in my first remarks, where they have quite a strong preference for the majority of any equity-based pay to be provided in the form of rather complex, or at least more complex than the alternative, performance share units. I think you're right, Keir, that this has an influence on which elements are chosen by companies and how they're emphasized. And that is a peculiar thing because to our knowledge, there is no evidence that PSUs work better in driving performance than simpler stock grants. The little data that's out there, on the contrary, shows the opposite. But I would emphasize there is little data out there. But when we run our data across 1,800 U.S. companies, we do make the same finding, that there is no basis for the intuition that I agree many people have, that multi-year performance conditions drive performance. So I think this is one of the reasons why pay has become more complex than, in our view, it need to be. And it provides causes some distractions, sometimes some problems. I would be also eager to hear what you were saying about that, Deborah and Michael, from the corporate perspective, when things turns out different than you had expected. Thank you.
Keir, can I just add two other examples?
Or
there?
three.
Or three.
Go, yes.
Of how proxy advisors might specifically influence the board and management in pay design. I think really what's influencing is maybe not so much the policy itself, but the recommendation that the proxy advisor is making on the say-on-pay vote specifically. So the policy leads to the recommendation on the say-on-pay vote. The recommendation on the say-on-pay vote is correlated to about a 25 to 30% swing in say-on-pay. This is a significant swing for boards and for companies. It absolutely will influence how they design pay. And although the larger investors, will say, hey, we're not, voting right in lockstep with proxy advisors, I think we know that some of the smaller investors might be more likely to be doing that, and that's why you're seeing that swing. So because of that, a couple of things. As an example, proxy advisors generally have a list of pay practices which they view as problematic under any circumstance. That has been extremely influential on management and companies in terms of just avoiding those practices altogether. So whether or not they think it's best for the company, if it's going to single-handedly drive a negative proxy advisor recommendation, it essentially goes, which is why we've seen such a homogenization of executive pay, over the past 10 to 15 years. I think it's impossible to ignore that there's just much, much less difference between companies than there used to be. The choice of option versus performance share, would be another. I think the third example is the ubiquitous use of relative TSR as a performance metric. So I think you'll find that before the proxy advisors kind of zeroed in on that as sort of the definition of pay by which we're going to do our pay performance analysis and thereby come by a recommendation, then you saw companies feeling obligated to include relative TSR as a metric in their pay plan, even if it wasn't necessarily what they would have come to on their own. So from that perspective, I think it's been quite influential.
Deborah, I noticed you nodding your head. Is that consistent with your experience as chair for the PNC Human Resources Committee?
I'm just offering emotional support.
Thank you, Deborah. So appreciate that.
Certainly, the proxy advisors, their policies, their practices are important contextual information amongst a host of important contextual information, including investor feedback. And there is overlap in those two subjects. And so it's important for the comp committee to understand that context, to understand the decisions that are being made in that context and how things will appear to investors and proxy advisors. But at the end of the day, the role of the committee and the board is to make the right decisions for the company at that time to drive shareholder value.
Okay, before we lose.
Chair,
yes,
can I just make a
please.
comment on that?
Of course.
You know, having been at a proxy
I was
advisor
going to say, Bob, I wasn't going to call you out, but I'm glad you said.
and as a user of proxy advisor information at Fidelity, it's interesting the influence is thrown around based on very limited data, I would say. The biggest investors use multiple proxy advisors. The voting results have been about 1 to 2% failure rate, and the recommendations against have been 8 to 14% over the last 10, 12 years. So there's a clear disconnect. I think to the points of their policy, it's not the tail wagging the dog, because both firms engage frequently with their clients to find out what their clients think about the various issues, right? So if their policy is to vote against a board because they repriced options, that investors aren't doing that because the proxy advisors told them to. They're doing that because that's their policy. And I know that because when I was at Fidelity, that was a policy before the proxy advisors even had that policy. So I think there's obviously some influence, and I think it is on their recommendations. But I think it's more about when they make a recommendation against, the investors then use that as a means to look more closely at the issue. If there was more of a pure reliance, we would see a much higher vote against. And on the types of equity vehicles, I think that comes down to a philosophy. That's also often pointed out as an error. Oh, you know, Glass Lewis, ISS, their reports have errors because they say these grants are not performance-based. It's really a philosophical difference, which is borne out by how their clients view these issues. So I think that's the way they've approached it. But in terms of, you know, the interactions I've had when I was at Glass Lewis have been always really constructive with companies. But I always asked, you know, what are your investors saying? And if our recommendation was against and the overwhelming vote was in favor, I would kind of scratch my head and said, what are we missing? But I know there's at least one company here that uses restricted shares, not performance-based at all. And Glass Lewis engaged with them quite constructively and would support their program. So that's a benefit of engagement. And I think that's something we haven't talked about yet is the engagement with shareholders. And we'll probably get to that anyway. But I just want to clarify the role of proxy advisors is not to set comp, not to step into the shoes of their clients, but really to provide information and data to their clients, who many of whom have helped the proxy advisors set their own policy.
Bob, I'm so grateful for that comment. One, because you're always thoughtful, and so I appreciate your thoughtfulness, but also it's a great segue to the next question. The next question was going to be, what role do actual investors play in this executive compensation setting process? And I'm not going to double up on you, but maybe I'll come back to you after that. But Michael, I love your perspective. So we talked about proxy advisory firms, one of many factors that are considered in setting compensation. I know investors are another huge stakeholder in that process. Can you talk a little bit about what that engagement looks like?
Yeah, I mean, the annual engagement cycle happens during the proxy season, and then there's usually an off-season engagement as well. During the proxy season, the engagement tends to relate specifically to the proposals that are in the proxy statement. Investors, of course, are at liberty to ask whatever questions they want. I will say that in recent years, it's been my experience that there's been pretty little interest in compensation in terms of the questions that have come up during during investor engagement. I think that it tends to spike in years following a difficult say-on-pay outcome. And that's when you get most of the compensation-related questions. But in recent years, what I've seen is a lot of the questions that didn't relate to the specific proposals in the proxy statement related to broader governance concerns. It was things like, board refreshment, director selection, overboarding, things like that. So comp has been pretty quiet, at least in my experience, the past 3 years.
Blair, I would imagine that you have many clients that get you engaged before their engagement, no pun intended, with investors. Tell us a little bit about that.
Yes, so I think that the engagement, if you do have a reason to talk about your compensation, is an opportunity to set the table about how your programs are aligned with your strategic priorities and your talent needs and your culture. It's also an opportunity to share some of the decision-making process that you have. So a lot of the work that we do as we work with our clients is to say, how do we help the investor understand how and why we made the decisions and what the business context was, so that that can be conveyed in the discussions, and there can be a dialogue with the investor to understand does the investor get the storyline here? Do they see some holes in it? And hopefully, we come to a constructive place. So the whole purpose of all of this is to set up dialogue and to try to provide more transparency into the process. Now, of course, there are rules about how much you can disclose before it is actually in your public disclosures. So there are also some decisions to make about whether you actually file the documents you're going to use, et cetera. And we go through those decisions. But by and large, we're trying to figure out the best storyline. And I think all of this sets the stage, what Michael was talking about, and I see Deborah nodding, for the story you're going to tell in the proxy. And if we come back to, why we're here today, I think investors want to know the rationale for why you made the decisions you did and what the inputs were. And so both the engagement and the prep for your CDNA can help with that.
So I'm going to take my moderator hat off for a moment and just share as a, former corporate secretary. And as I look at this audience particularly, I look at Drew Hambley, who's going to be on another panel, who, when I was at a prior company in that corporate secretary role, we engaged quite extensively. I'm looking at John Rowe, same thing. And as we had our conversations around executive compensation and preparing for not just for the proxy, but really thinking more broadly as an organization, the feedback that we got from investors I found incredibly useful and valuable in informing our management team around what our top investors thought about best practices, et cetera. And so just want to say, we've talked about proxy advisors. We've talked a little bit about the role that investors themselves play, but that one-to-one engagement opportunity, Norges, I mentioned to you, Ola Peter, we engaged with your team, extremely, extremely valuable in the process. Do you want to add to that?
Yeah, happy to add to that. And for us, the most interesting and relevant engagement is the engagement that does not happen in the last 2 weeks ahead of the shareholder meeting. So we're very happy to, and we spend a lot of time on engaging with our key holdings. I must admit we're not able to engage with all 1,800 US names we're holding our portfolio, but the vast majority in terms of value we engage with, and we're very happy to do that throughout the year, and with decision makers at the company, in addition to our regular, often quarterly updates with management on how the business is going. And we do that for several reasons when it comes to compensation. One is that we want to get a better understanding of the real incentives of management. So what is actually happening in terms of compensation? And that might be a little bit more complex than what's on paper, even though what's on paper is complex enough, 40 to 70 pages often in the proxy statement. So that is quite important for us to try to really understand what's driving the management in terms of monetary incentives. Second, we want to discuss with decision makers what good incentives look like. We want to try and understand what they are doing to commit, especially the CEO, to the stock long term, and to the degree they are using multi-year performance conditions, which is not our preference. We're still interested in discussing how they are chosen, weighted, calibrated, and followed up on. So that is very much in our interest to do. But I must say, we're also quite often hearing comp committee members, board chairs, others telling us when we have discussed kind of the principled approach to compensation that, wow, we would have liked to do it as simple as you suggest, even maybe open to making the stock lock-in longer than the 1 to 3 years. But it's very difficult given the environment we're in and the risk of negative recommendations by the proxy advisors. Thank you.
Very helpful. So I'm going to pivot. So we've talked a little bit about the stakeholders in the decision-making process. Now we're going to change our focus to the decision-making process itself and the elements of compensation that are decided on as part of that decision-making process. And so, Blair and Michael, I'll start with you. So how do companies determine the breakdown between cash compensation and equity compensation, as well as guaranteed comp versus compensation that's at risk? Do one of you want to kick that off?
So this gets back again, I feel a little bit like a broken record, to the strategy and culture that you're trying to drive. So if you are a company, who is a startup or high growth, then you might decide to have a mix of pay that's lower in cash and higher in equity. If you are a more mature company, you might find that you want a more balanced mix of elements that's more, it's still going to be heavily weighted towards equity, but it's not going to have the high upside that perhaps a high growth company might have. So that's one distinction you might make. So understanding what type of company you are, where you are in your life cycle, and what your opportunities are for growth is an important input. We do look at competitive data, but that would not be, it's not a benchmarking exercise where we say if peers do this, then we need to do this. But we do want to know how we compare, and if we're going to be different, does it make sense that we're different? Have we made that decision deliberately, and is it helping us in the marketplace, both with talent and with our results? So those are the kinds of decisions that go into the cash versus equity mix. Now, when we go and we think about like the types of equity vehicles we use, they're similar inputs. Stock options happen to be very good for companies that are on a growth trajectory. So you'll find those stock options in industries that have higher growth or are newer in the marketplace, and they can be a very good vehicle for that. You find restricted stock can be very good for stability. So companies going through turnaround or more mature companies, it just provides a stable part of the equation. And then performance shares, which, they clearly have pros and cons, as Ola Peter has pointed out, but they can be particularly good at directing performance and highlighting priorities for a business at a time of change. So if you put a new strategy in place and it has several priorities, out there for the company, and you align those must-have objectives in your PSU program design, it can be very effective. Where it's less effective is if you're just using sort of standard measures. So what you want to make sure as a committee is that what the CEO is saying and what you're trying to communicate in your investor days about your priorities are directly captured in those programs. And when done well, then they actually can drive performance.
Yes. The only thing I would add to that is, we and all of the companies I've worked for, I'm not necessarily speaking on behalf of my current employer here, we've always considered sort of what peer practice is. It doesn't dictate the outcome. We don't slavishly, adhere to what our peer companies are doing, but it's good to know. And then the actual incentive structure, the pay mix, is made bespoke for the company in question to align incentive effects with the strategy of the company. So there's always this tension between balancing incentive effects over multiple time horizons, which is why you've got annual incentive plans and you've got long-term incentive plans. You want executives making decisions that work in both the short term and the long run. The metrics that are used should also have tension. Focusing on just revenue growth at the exclusion of profit makes no sense. It has to be profitable revenue growth. Focusing on profit at the expense of revenue doesn't make sense either, because you can maximize profit by ceasing to invest in the business, which would also hurt your long-term prospects. So it's balancing all of these things, and it's also balancing the incentives with the need to retain people in different markets, particularly volatile markets, which is where the RSU versus stock option versus performance share discussion comes in. RSUs are inherently retentive because they're durable even in down markets or flat markets. Options do nothing to retain people in down markets or flat markets. PSUs are kind of a mix. And then the other thing I would say is that the stock price itself creates sort of a long-term incentive. Anything that's denominated in stock is going to fluctuate in value with the share price, whether it's any of those vehicles that we've been talking about, options, RSUs, or PSUs. Ideally, the metrics should have some combination of sort of explicit explicit stock price acknowledgement, whether it's absolute share price or relative TSR. But ultimately, the financial performance in the PSUs and in the annual plan should be value drivers that can sort of demonstrably show up in the share price in the long run. So that's a lot, but those are the things that I think committees and companies grapple with when they're designing programs.
One other element I forgot is the cultural element. So sometimes you want to be one team, one dream, and that means you measure everything at the corporate level, but sometimes you need to drive accountability through your business units, or your business units operate pretty autonomously from each other where they aren't sharing resources or talent. So you want to drive the measurement down, at least in part, to the business unit level. And really, for most companies, you go back and forth on that because there are times where you need to get everybody on the same boat, and then you've optimized that piece of the culture, and then you need to drive accountability back down and you go to the other direction. But those conversations need to happen each year with the committee to make sure that what you're doing is having the effect you want, and that you aren't getting misaligned and having unintended consequences from the compensation program.
Yeah, and if I could just add one thing to that, I'm sorry, I don't mean to dominate the conversation, but I think the point that was made earlier about compensation committees taking on a broader HR remit goes exactly to what Blair just said. I think there's an acknowledgement on the part of boards and management that culture is incredibly important, the cultural health of an organization, and those things I think increasingly are getting embedded in incentive plans, either through an individual component of an annual bonus plan, or through other mechanisms, a corporate scorecard.
One other point I'd like to raise that is, I think, extremely important and hasn't been mentioned in both setting the mix, the metrics, the structure. I do think the committee has a significant responsibility to also discourage excessive risk-taking. And it's obviously important at PNC because safety and soundness are a business imperative. I would argue it applies really to every type of corporation. I remember hearing about Fidelity's portfolio management compensation structure a long time ago, and I thought it was brilliant, is they sort of stopped paying the portfolio managers more when they got over 80% above the benchmark or whatever it was, because they didn't want people swinging for the fences. And I do think a really important part of a board member and a committee's role is to make sure these structures are fair and balanced. They encourage outperformance, value creation, and also manage risk. And that's just an important component that applies to all companies, but certainly people in financial services.
So we were going to talk a little bit about the ways that you can create incentives around equity compensation. And Deborah, I love what you just shared, because that risk-taking and trying to think about that in the design of an equity award is really, earlier someone mentioned culture. So can we just spend a moment on how do you use different elements of compensation to address cultural values that you want to reinforce or behaviors that you want to discover? And maybe, I don't know, Blair, I'm looking at you and Michael as I ask this one, but I'm sure that's part of what you have done.
Yeah, exactly. We've made it actually an explicit part of our annual incentive program via the performance management process. So, everyone at MasterCard, their performance review reflects their demonstration of behaviors. So it's not just results, and this was something that was consciously done a few years ago because we wanted to make sure that people not only accomplished their goals for the year, but they did it in the right way. And it's not generally not acceptable to sort of achieve goals at all costs. So that would show up in your performance review. So individual salary increases, bonuses, those things are impacted by the way you demonstrate behaviors that represent the firm's values.
How do you measure that? Like, how does one measure that as part of the process?
Yeah, I mean, it's it's largely a discretionary exercise, but there's a lot of structure that supports those decisions on the part of people managers. And this, I'm not just talking about executives here. I'm talking about the entire employee population. So there's a lot of rigor and education around what it means to demonstrate those behaviors at different levels. And that gets, reinforced every year. It's not just something that sort of hangs up on the electronic bulletin board. It's constantly reinforced, throughout the year in various conversations that occur between people leaders and their employees. So that's kind of how it works.
Yeah, and I think you can see that in proxy disclosure when companies have individual measurement and you see differentiation among the group, then you see that a committee actually has been rigorous. Now, sometimes, again, a team has won together and you'll see everybody getting the same adjustment, and that's okay too. But, those are decisions that the committee is wrestling with, is what kind of year is it and how have people contributed in that way. The other cultural things are the things I talked about in terms of do you measure at the corporate level or do you measure at the business unit level or the team level? That makes a huge difference. And in addition to doing merit increases and changing the bonus, companies are increasingly using modifications to the equity awards and taking those up and down, because that's the biggest part of compensation. And you can capture who are the people who are building your organization for the future in the ways that you want.
Ola, Peter?
Thank you. And as we can hear across the table here, I mean, it is clear there is a lot of thoughtful work going into this on the corporate side and on the board side. That said, I mean, if you have with an eye to the academic literature in this area, most people are well-intended, have good intentions, but sometimes you have a situation where incentives make decision makers try to reach that goalpost almost at any cost. And I think we will know from our practical life with corporates that this is a real issue. So I appreciate all the work that goes into kind of trying to resolve this, but I just wanted to put out there that another core driver of attitudes and culture is that we know that we're all in the same boat. We're going to hold on to this stock for a really long time. And I think it's very powerful when you have a CEO and a management team that know that we're in this stock for 5, 10 years, maybe even more. So not only me, but also my children and my grandchildren depend on how this is going long term and even after I've left the ship. This very simple alignment plays a big role, and it's very intuitive to us. We are long-term shareholders. We're going to stay a key shareholder in most of the companies around here for the next 50 or 100 years at least.
Ani, I want to come back to you, if I may, thinking about this question around performance metrics and targets, and how are those determined from the vantage point of a management team or a board?
So here again, I think Blair kind of mentioned this, but the objectives of the company come first, right? So the strategy and the objectives come first. Then we choose metrics that we think are going to align, with those objectives. To me, I think one difficulty that companies sometimes have is that what proxy advisors or investors are expecting in terms of a 3-year plan with a specific number of performance objectives that are somehow supposed to align with long-term stockholder value for that company, it just isn't the case for that company. And in that company's situation, they do wind up, I think, in some cases, almost being forced to go along with what the one-size-fits-all model says they should be doing rather than what they know would be best for their own company, and there's just no flexibility to do that in the current circumstance. I think we're gonna talk about this a little bit later, but the way that the summary compensation table is structured, I think can sometimes contribute to that as well.
That's a little bit of a segue. I'm going to come back to that because that's the point of the whole panel. Before we get there, though, we've talked a lot about equity. We've talked about salary. Let's talk about some of the other elements of compensation. So one area that's gotten a lot of attention of late is around security, personal security for executives. But I know that's in a whole universe of perks with air quotes, that could be provided. So can we talk a little bit about how each of you, from your vantage point, whether it be from a comp committee chair, as an investor perspective, et cetera, think about the other elements of compensation that you introduce into a compensation award for a named executive officer. And Ani, since I'm looking at you, I'm going to go with you first.
Sure. So, just one thing I always point out, we're talking about this, is that the all other compensation table in a column in the summary comp table is like 2 to 5% of total pay. So we are talking about a small amount of money comparably to the rest of, but it gets a lot of outsized amount of scrutiny, of course, for a variety of reasons. But the one that I really wanted to talk about today was definitely the SEC's definition of executive security as a perk. So I know we've all probably talked a lot about this, but the fact is that you can have practically the exact same security at your home that you have at the office. The security that's required for you to have at the office as the CEO is a business expense. That same security at your home where you really need it because you work from home once a week is considered somehow to be a perk. So I think that is an area that has, to some extent, at some companies, driven practice in the sense that they may not have all of the security that they need or would like to have because they're concerned about it being added to total pay in the summary comp table. So,
I want to come back to that, but before we do, any other elements of compensation, not salary or equity, that we haven't talked about that should be put on the table as we're talking about other significant elements of comp? Because otherwise, I do want to come back to this perks question in a moment.
Well, I mean, the other things that are captured periodically, so severance payments or relocation payments, and those can distort summary compensation table pay. And because they're just in the table, sometimes the nuance behind why and what doesn't always get captured.
All right, it's my time to be provocative. So here's my provocative question. So let's assume that there are no changes to the SEC's rules around perks. And so personal protection at an executive's home continues to be viewed as a perk. So what? That's my question. So what? So why does that matter if at the end of the day you're a firm and you say, that's an expense I'm willing to take on, it's just a disclosure item, move forward? What do you think?
So I actually think if it wasn't added to the executive's pay in the summary comp table, that would be a different story. So it's one thing to say all you're doing is disclosing it, yes, but if it's added to the executive's pay in the summary comp table, now the scrutiny of that executive's pay has just increased on the basis of something that shouldn't be a perk. So everybody in the world that is using the total pay column in the summary compensation table is now using that number, possibly not realizing there's $1.5 million in there of private security that was needed because the guy's daughter was threatened, right? So I think that's actually more of an issue than the just disclosure. My thought.
I'm going to stay with this one. So the total compensation goes up. So what?
So now the proxy advisor uses that total pay number when they're doing your pay for performance analysis, and maybe they come up with a red flag, and then investors start looking at it, and then they say, well, I don't understand why this executive's pay is higher than his peers in the industry. But it turns out he's had a direct threat assessment done, the other executive hadn't.
All right, Deborah, I'm turning to you on this one. I'm continuing the so what question.
Oh, no.
I'm continuing. All right, so Deborah, let's set aside your current board role, your current CEO role. So just as a director on abstract, unknown company to be named, you've got a senior executive where you think there is a credible threat against her or his personal safety. And we're telling you as your advisors, Deborah, if you give that personal security at their home, it may be disclosed, it may get a negative mark from proxy advisory firms. Does that change your advice with what you do for that executive?
Well, it is a sad reality now that personal security of visible executives is a real issue, and of their families. And I can tell the audience that many executives don't even really want, and sometimes even will fight against, having personal security at their homes. But it is really a business imperative in some cases that there is security around the clock for certain of the executives. And I think we would be derelict in our duties as directors, forget about comp committees, if we did not protect important assets at the company. If you had a data center and someone said we're going to hurt the data center, you would have security around it. Well, you would do the same for your NEOs, your directors, other members of the team. We would do that for a teller.
Right.
And so I do think that we would have no question about, to directly answer your question, no question about providing that business security, regardless of how it ends up being disclosed. And I do agree it would be appropriate in those cases if it isn't in the summary comp table, but even if it is, you have to do what's right for the company.
Yeah.
And that's what it would be.
Thank you. I was definitely driving to that answer. I'm going to acknowledge that. Ola, Peter, and Bob, you are both extremely reasonable investors. So let's use this generic, anonymous company that we were just describing. The company makes the decision, we're going to protect our executive because she or he has received credible threats. You see that in a proxy. What's your reaction?
It's a very quick answer. It's not a perk. It's for protection. Full stop. A perk is something that CEO is getting that not every other employee is getting. Free car, country club membership. When it comes to security, I think we're belaboring this because it's really that person's security. It's a matter of how it's disclosed, and if proxy advisors should back it out or investors should back it out, like the change in actuarial value of pension programs, which I know Klaus Lewis backs out, then that's something they should factor in. But if it's just for security, it's not a perk. It's almost a requirement, and it should be treated accordingly.
Agree, no issue.
Okay. All right. I like that. I like this outcome. We're gonna stay with this. So that is one example where I think the SEC's disclosure rules may not ultimately change, but influence the decision-making process around an element of compensation. I'm going to pan back out. We've talked about cash versus equity. We've talked about guaranteed versus at-risk compensation. We've talked about long-term versus short-term. And so and perks. And so in the context of the current disclosure regime, do the SEC rules limit or encourage certain compensation decisions? And I see some head nods. I think the answer is probably yes. But maybe, Ani, I'll start with you, and I'd like the panel's perspectives on that.
Sure. Yeah. I think it's a tricky question because, at the end of the day, I think as everybody, especially the companies on the panel have said today, the company really tries to do what's right. But I think it would be crazy to say that it's not influencing. So just a couple of ideas that I had or suggestions where I think that could be the case. I mentioned the summary comp table, and I know that the next panels are going to get into this in detail. But I think that the fact that the summary compensation table includes multiple definitions of pay. So it kind of includes pay that you're giving at target, but it also includes actual cash pay that you receive. Then it includes a pension. What if you don't have a pension? Then it has this all other comp table. What if you don't have security? I think that could be influencing the way that companies think about pay. So we talked to an employer who said, we have kind of an unusual pay plan where we do use performance shares, but we almost never pay out above target. So that is sort of embedded in the way that we grant the equity. We have basically a different way of granting equity. But when it gets put in the summary comp table, we're at a disadvantage because of the fact that it's done at target, and these other companies that are actually winding up paying more in performance shares, it's eventually disclosed, but it's not in the same way in the summary comp table. So that's an area where a company could actually be influenced or feel forced to grant it in a certain way because of how it comes out in the summary comp table. I also think just this question of who's in the summary comp table can sometimes influence decision making. So I think I mentioned earlier that executive compensation is a powerful form of communication. You communicate quite a bit by who is a named executive officer. And sometimes it's not what you really intended to communicate. Those three officers below the CEO and the CFO are not comparable in the same way that the CEO and the CFO are. And so sometimes I think you have seen companies feel like, do we need to make a pay decision that keeps somebody out of the summary comp table or make certain that they're in the summary comp table, because if they're not, we may be communicating something we don't intend to communicate.
So we have to protect the innocent on this one, but I'd love others' perspectives. Has anyone else experienced that kind of decision-making where an executive is seeing, let's say it's a CEO, is thinking about what disclosure would be in the table for NEOs and making decisions in compensation based on who they want to be in that table and who they don't want to be in that table? Maybe, Blair, I'll ask you that question because it won't be attributed to an individual company.
Yes. So, yes, it happens. I mean, it's not all the time. It's not every company, but you can imagine, particularly on that fifth highest paid, people tend to come in and out of it. So some of it is not even about signals you want to send to the individual, but it complicates your disclosure if you have a person come in for 1 year and then they're out. So yeah, it will happen.
Thank you. So we talked a little about the role of perks influencing decision-making or perk disclosures. We talked about the existence of the summary comp table being limited to NEOs influencing decisions. We talked a little bit about equity awards. Are there any other examples of executive compensation disclosures that impact the decision-making that leads to those disclosures? Ola Peter.
Can I mention something that isn't there that maybe even...
Yes, please. Yes, please.
So one thing that is not consistently disclosed is whether equity-based pay pays out in equity. And as an investor, we of course would like equity-based pay to as high extent as possible to pay out as equity. But that's not consistently even disclosed today. So that could be a very simple thing to do, simply show how the company settles equity-based pay. And I think many investors go around thinking that equity-based pay results necessarily in equity being handed over to the CEO.
Very helpful. Okay, Michael, you lean. Oh, sorry, Blair. You have something you want to add to that?
I have one more example.
Please. I bet there are a lot, by the way, but keep going.
Sometimes it makes sense to do a multi-year award, and because the summary comp table pay is oriented towards annual pay, you get way out of sync if you put so you have to really think about that, and then you end up with machinations of how can we minimize that number when, it may make sense for a turnaround, for instance, when you've brought in somebody new to really change the game dramatically, and the summary comp table just isn't set up to help that be understood.
Yeah, I agree with everything that's been said. I think, there are risks of distortion in practices because of the rules. The perquisites are probably the most obvious in my experience. Most companies assiduously avoid or minimize perquisites. The NEO inclusion is another area where I haven't actually seen a decision be distorted by that consideration. But there's a lot of nail biting that happens, as you're going through that process, when someone could end up in there that doesn't make a lot of sense. And the mega grants obviously is another thing where it might make sense to grant that, but you're just highly discouraged from doing it because of the disclosure rules. But from my perspective, it's not so much about distorting decisions. It's more about the amount of effort that goes into the disclosure. The juice that you get from it doesn't seem to be worth the squeeze. Entire teams of people are spending so many hours preparing this, and you sort of look back on it and you ask yourself why. Like, what did we really accomplish by doing it?
Yeah, and here, one of the examples is particularly financial firms, often they grant bonuses after the close of the fiscal year. And I've seen some actually add a second summary comp table and make it very clear this is not to satisfy the SEC requirements, but it makes a more apples-to-apples comparison of the performance of that year, and it's helpful as a user of the information.
So we're going to transition to our last topic of the day with about 15 minutes left. And Bob, I was going to stay with you. So we've talked about a really complicated, involved process. We talked about all of the people involved in the setting of executive compensation, from outside counsel to advisors to people doing calculations on top of the management team. We talked about all of the complex thoughts that go into the decision-making process itself. We've talked about, the role of proxy advisory firms and investor engagement and all of those things, the benchmarking, the excellent advice from firms like Simler Brossley. My question for you is, how good are the SEC's rules at revealing the material elements of all of that in addition to the compensation itself? And Ola, I'll come to you after that.
I'm going to use a really bad analogy. In high school, I worked at an ice cream store, and I used to make the ice cream, and I would make these horrendously bad flavors like rum raisin or maple walnut. I said to my boss, why am I making this? She's like, there's one woman who drives 30 minutes. This is the only place that has this particular flavor. So I look at that, some of the compensation disclosure, for them, that's a very important aspect of the disclosure. It could be the pay ratio, not on an annual basis, but it could be something they compare year over year. They could look at the pay for performance table and not look too closely at the information necessarily, but say, geez, this gives me 5 years of data. I want to think more longer term, like Olaf Peter alluded to, and the CII guidelines prefer 5 years or more. So that could be an important part of that. So there's a lot of compensation disclosure that is being used not in a way that was initially maybe intended, but is actually very valuable, maybe to a small subset of investors. So when investors are looking at the overall disclosure, they may be gleaning different pieces from different parts of it. They start with the summary comp table. But Ani, to your point about, two companies, one grants very challenging performance metrics along with its awards, one it's very easy. That's probably the hardest thing for investors to really understand, is how often are those grants being actually paid versus how much are the ones always being paid. So I think that's probably the biggest struggle for investors. And I think the disclosure's there, but you sort of have to dig. To your point, it's the numbers in the summary comp table, but you have to find the disclosure elsewhere that it was either not paid or only paid at 80% or something like that. So I think that's the challenge for investors overall, but there's significant disclosure in a way that investors can use it in a way to figure out, are the grants being made in a way that is tied to strategy? What are the selection of the performance metrics? How do they tie to the strategy? How is a peer group selected? How is that altered over the years? What are the nature of the short-term performance bonuses? All those factors may seem, in the abstract, maybe not all that helpful, but in totality, they can provide a much fuller picture of how the compensation works in practice. And I'll harp on the time frame. If you take an AI company versus an oil and gas company, to think of 3 or 5 years, for each of those, one's way too long, one's way too short, right? So it's understanding, has the board thought through these? Have they developed a compensation program? And have they made changes to that program? And that's where there's some issues sometimes where, a one-off award to an existing CEO to retain that person, does that mean the current compensation program isn't working? So those are sorts of additional narrative, more qualitative analysis can be really, really helpful. Because otherwise, if you just look at the numbers, it may raise a red flag. I remember engaging with a company that they aspirationally compared themselves against Berkshire Hathaway, which I thought was really nice. But they said the only thing they look at is ROIC. They don't grant any dividends. They don't do any share buybacks. But the Glass-Lewis model didn't capture that. ISS model, really no investor's model. So we looked at it, and we determined that we're actually, at Glass-Lewis, not to use our model at all to evaluate that company, but not having that additional discussion. And they enhance the disclosure, I would say, in response to that. And sometimes it's just the additional disclosure can be extremely helpful beyond what is required. And it's, my boss used to say, don't let what's required get in the way of what is actually really helpful. Did I avoid the question completely?
No. I'm going to come back to that because I was actually going in the direction of less disclosure is more, and I think what you're asking for is more disclosure. So we'll come back to that in a moment. But Ola, Peter, you first.
Well, it's a complex issue here, but let me just add on to a little bit what Bob was saying. Even though we have all this disclosure today, it is incredibly hard to follow one equity grant through its life and really understand what's happening there. And this sounds like a trivial issue, but it is super hard. And sometimes we sit down and try and pin this down, and we almost get there. But we're not able to do it completely without significant guesswork. So I think that is a quite simple fix that the SEC could make. So make it possible to follow each grant through its life. That's one thing. The other thing, which is inherently difficult, is what also Bob talked about, which is, and you talked about it as well, Annie, understanding what is a target. So total comp assumes achievement at target and vesting at target. But that's the only thing you really know is the threshold and the maximum, and the target is somewhere between there. And companies have different philosophies on that. We calculate all of this more and more, and I think on average across our 1,800 U.S. names, a grant tends to the median vesting level is at something in the area of 115% of target in any given year. But getting to what the target really means here, is that a stretch target, or is it something that they're pretty sure will happen? And my last point is maybe a question to you on the corporate side, and maybe also the advisors. Would this be easier if you were allowed to simply pay in restricted shares and choose a time horizon for that lock-in that works for your company? What we are saying in our policy is that the lock-in should reflect the length of the business cycle for the company as the board sees it. And then to illustrate, we say 5 to 10 years, just to illustrate what we're thinking of. But it's really down to the company and the board's assessment of what is a reasonable length of the business cycle. So for how long should we lock in the stock? So my question is, would this be easier from the corporate side if you were allowed to do it much, much simpler?
I suspect the answer will vary, but Ani, I'll look at you first and then go down and see what others think.
So I think you used a very important word, which is if you were allowed. You didn't say if you were forced. So I think that if you are allowed to do it, there's no question that for many, many companies for whom a 3-year performance grant just doesn't make sense, it doesn't align with their business cycles, that what you're describing would be easier. But I think that if it somehow became the case that now you're required to do it that way and you're forbidden to use performance shares, we might be back where we started, except in the reverse. But I don't know, Blair, what you're...
Yeah, I agree with that. I mean, I think you have to allow for both and, because there are times when performance shares can make a difference. Again, when you've got a time of change, it can be very helpful in the communications to the populations about the priorities, and it can add urgency to must-have objectives. But there are other times where you're trying to manage the business and you've got a lot of change underlying, where actually a longer-term restricted stock unit would make a lot of sense. And I think having the flexibility to go either way and show why your business situation suggests that would be helpful.
So we have like 2 minutes, I think. So here's what I'd like to do, because we're not going to resolve this today, but you all heard the introductions from each of the SEC commissioners and the chair who spoke. If you can make one suggestion for the staff to consider as they're thinking about how to better align the disclosure of executive compensation with the outcomes that we want, what would those suggestions be? And maybe Bob McCormick, I'll start with you.
This was not one of the original questions that
I know,
Kira
that's what I do.
provided.
I'm sorry, I'm here to mix it up. Yeah.
I think maybe to some of the points we've raised here is about considering flexibility for companies who don't fit a more typical framework, that is in terms of time frame, type of equity vehicle. I mean, we've sort of fallen into this kind of three-legged stool of salary, bonus, and long-term comp. Maybe some programs are better off more medium-term or complemented with a longer term. So I think maybe being adaptive and open to different approaches that companies may take, that really makes sense for them.
Michael?
Yeah, I think simplification is probably the top priority from my perspective. There's so much disclosure. You look at sort of the volume of pages in a proxy statement with all of the tables. It's, like I said earlier, it's very rare that I get a question about compensation. No one has ever asked me once about the CEO pay ratio on the investor side, nor about the pay versus performance table. Like I said, a lot of effort goes into this, and I'm just not sure what the utility of a lot of the information is. In my view, the CD&A should be principles-based, and it's incumbent upon companies to demonstrate how their compensation programs align with the business strategy and ultimately shareholder interests. And if they can do that with less, that's better. A lot of the tables could be probably eliminated, and some of them could be consolidated.
I think simplifying the summary comp table, so we're looking at like-for-like compensation throughout the table.
I would say back to Commissioner Peirce's comment about, at this point, we seem to be disclosing things just because people feel like reading about it. I was really
That's the
impressed by
that's
that.
the rum raisin
Yeah,
customer who
the
drives
rum
30
raisin.
miles, by the way.
So I'm not saying we should have like a Hunger Games style competition for what gets in and what gets out, but I do think maybe really rethinking the concept of materiality as it relates to executive comp disclosure would be the most useful.
I'll mention a few questions that could be up here, but I will be very quick. Disclosure of whether stock-based pay will settle in stock or not. Disclosure that makes it possible to follow each grant through its life. Disclosure that makes it possible to understand adjusted figures, which we haven't talked about here. What's the policy ex ante and what's the reconciliation ex post? Maybe breaking down each grant in its tranche if there are several performance conditions. Put it down maybe in a Gantt chart style disclosure so it's possible to have the full picture. And maybe the last one, making it possible for companies that do it super simple to also have a super simple disclosure.
Deborah, bring us home.
Okay, well, all of the suggestions are interesting. I think you're adding more. I do think following a single tranche of stock And I'm trying to understand the use for that because, you know, if you own a share of stock from 1990, it's the same as a share of stock you got in 2025. So you don't want to seem to look at it on a consolidated basis for the executive. So I'm trying to understand. So that goes back to my suggestion, which is I do think each of these rules should be put through the ringer again of a very rigorous process of what the investor is getting out of the information compared to the effort involved in producing the information, and should be rank ordered so that there's a strong business case for what is included in the proxy, and maybe some good results could flow out of that.
Great, thank you. I'm not even going to try to sum that up. I'll just say thank you all very much for your comments, your thoughtfulness. I appreciate it. I think it's time for a break. Thank you all.
Kier, thank you.
Thank you, Kier.